Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. Along with my co-host Jesse Barrientos, we want to welcome a special guest, the Honorable Judge Jesse Reyes. Jesse Reyes, welcome to the show today.
Thank you very much, David.
Today we're going to be talking about Illinois mortgage foreclosure law, and that is a particular area that you are presiding over in Cook County,
yes,
along with, I believe, 9 other judges sitting in that
approximately
circuit?
About 10 other judges.
About 10 other judges. So this is a topical issue that is very prevalent right now. People are in foreclosure. Foreclosures are record numbers. So we're very happy that you decided to join us today, and we're glad to have you.
Thank you.
Jesse Barrientos as well, co-host. Welcome to the show.
Oh, thank you very much, Dave.
Judge, if you can tell us a little bit about your background and how you came to become a judge and what you've been doing lately on the bench.
Well, I'll start from my current position. I've been with the Mortgage Foreclosure Mechanics Lien section of the Chancery Division since 2005. In fact, I, along with the supervising judge, Judge Lewis Nixon, were 2 of the first to be part of that program that was established by Judge Evans. Early on, Judge Evans saw that the numbers were rising and wanted to create a section that would be dedicated to answering and presiding over issues regarding mortgage foreclosures and mechanics liens. So we've been doing this since about 2005.
Before there was a section, Judge,
yes,
were the foreclosure cases just heard sporadically among the different chancery judges, or how was
Right. Yeah. The foreclosure matters were heard by the general chancellors in the Chancery Division, and they would handle every aspect of the foreclosure process, from the motion for a judgment of foreclosure to the order approving sale, and any other issues that may have arisen related to the foreclosure. And then around, as I said, around 2005, Judge Evans created the section, and now we hear everything related to foreclosures and mechanics liens as well. And prior to being assigned to the section, I was in the First Municipal, serving in domestic violence court, traffic court, and a variety of the branch courts around Cook County. And before that, I had the opportunity to be out in Markham, where I sat in criminal misdemeanor court and also in domestic violence. And then before that, I was again in First Municipal, hearing a variety of different matters in the First Municipal District.
I was going to say, I remember the criminal, certainly misdemeanor days. It's been a little while back there.
Right, yes.
Remember that. Oh, it's a little while back there.
Yeah, and then before going on the bench, I was an attorney with the Board of Education, and I was there before I went right on the bench, and then prior to that, I was with the City of Chicago in the Torts Division, and I was there for a number of years before I went to the Board of Education. So my background has been mostly civil litigation as a lawyer, both jury trials and bench trials, and in state and federal court.
Yeah, very diverse, though.
But no foreclosure experience.
Right. You've done a lot of things. That's commendable.
Thank you.
Let's talk briefly, Judge, about the current state of events that are happening in the country, and particularly in Cook County where you're sitting. What are we seeing in the foreclosure area?
Well, the number of foreclosures are rising in Cook County and throughout the country, as we all know. And the foreclosures are not only residential foreclosures, but now they're commercial foreclosures as well. So we're seeing an equal number of commercial foreclosures, and from a variety of different aspects. Some of them were buildings that were under construction, some of them are already constructed, some are office buildings, so it's a variety type of commercial foreclosures, and then residential foreclosures. And as I indicated, the numbers have been increasing. Last year, approximately about 55,000 new foreclosure matters were filed in Cook County. The numbers had been increasing since around 2000. There was a big jump in 2003. And that's when Judge Evans realized we have to address this issue because it's going to become overwhelming, which it did. And Cook County started seeing some of the numbers rising as compared to some of the other counties, but then eventually they unfortunately caught up to us as well. And now all my colleagues throughout the state that are dealing with foreclosure are dealing with large numbers of mortgage foreclosures, and also residential and commercial foreclosures as well.
When you look at commercial, what you said there's a variety. Would you say there were more in like mid-construction versus already constructed and just how would you?
Actually, it's both. I mean, we have some that are in mid-construction. They may have gone up, but the properties are vacant. They had the person who was going to purchase the property no longer was able to do so for whatever reason. And then some of them are fully, completed, constructed buildings. Let's say, for example, condominiums, where the condominiums were all set, but unfortunately, people weren't buying the condominiums, and the bank called in the note, and the whole building goes into foreclosure. So it's a variety of things. Some of them are businesses. Some of them, unfortunately, were mom and pop businesses that have gone under. So unfortunately for the commercial foreclosure, it covers the entire spectrum from A to Z.
So really, the economy is really hitting everybody kind of equally from every situation.
Right. Well, and unfortunately, because a lot of these businesses, like say restaurants, they're dependent on people's disposable income, and as we all know, with the economy the way it is right now, there isn't a lot of disposable income with regards to a lot of individuals that reside in the county and the state. So they're not, utilizing the services of the businesses, and unfortunately, the businesses are suffering as a result of it.
Judge, do you feel that the decrease in home values has led a lot of people to kind of give up on the house and decide to stop paying the mortgage, either in hopes of getting some kind of deal from the mortgage company, or it's just that their property is so underwater that they feel they shouldn't continue to pay for it? Are you seeing that?
Well, unfortunately, there's two things we see and we don't see. We early on did not see a lot of people coming to court for whatever reason, and that was unfortunate because we were entering ex parte orders, which means that the defendant, the mortgagor, didn't appear, and it could have been for a variety of different reasons. But one of the things that is occurring now is that we are seeing more individuals who are homeowners, who are defendants in foreclosure actions, coming into court.
Pro se?
Some of them are pro se, some are represented. Not as many as we would like. Again, the numbers, considering the number of foreclosures we hear on a daily basis, is not as significant, but there are more people coming in. And some of them are indicating that they're trying to work things out with the bank, or maybe doing a short sale. They're working out a modification, things of that nature. So there is some effort by the homeowners to try to see if they could resolve the situation with the bank.
Let's explain to the viewers at home kind of what a short sale is so that they understand. A short sale would be, for example, I owe a specific amount of money, but I'm able to sell it for less than that, and the mortgagor, the bank is willing to take that amount of money and get me kind of off the hook.
Correct. And that is a situation where the bank has to have final approval. So you might have somebody who's interested in buying your home, and they realize that they have to come up with whatever's due and owing, what you're asking for under the short sale. So it's contingent on a lot of different factors. Number one, that the bank's going to approve the short sale. Number two, that the person that you're trying to sell the property to is able to get some type of loan or some type of security to be able to purchase your home. Once all those come together, then you can have an effective short sale. But it's a process that you can work on and try to make sure that it comes to fruition, but you have to be persistent in making sure that all the ends come together.
Are the lenders willing to kind of work with the homeowners, especially now during these times, to be able to do something like that?
Well, we're hearing a lot of situations that people are working with the banks, and one of the things that we are doing as judges, we're entering a lot of orders of dismissal. They're without prejudice, which means that if something happens, the modification doesn't work out, or the short sale didn't take effect or whatever, the bank can later on come back and try to reinstate the case. But we are entering a lot of orders with regards to dismissal, which means that something's happened between the parties. They've been able to resolve it one way or another.
Great.
Yeah. I've researched lately, Judge, that in Cook County, among the judges that are sitting in your position, that the number of cases on your docket at any given time is approximately 6,500. Is that accurate?
I think it's a little bit higher. Then we're like around 7,500.
Okay. Because in other areas of the law, that would be completely unmanageable. I don't know how you're managing it in foreclosure court. Is it because a lot of the mortgagors are not represented or not defending the case that these numbers are so high?
No. Part of it has to do with, you have these large number of cases being filed every year. 55,000 last year. The year before that, I think it was in the ballpark of around 45 to 47,000. And these numbers, keep increasing. If you go backwards, you'll see the numbers keep increasing. So we have a lot of these cases that are in our calls. Sometimes the situation is that they're trying to work something out. There may be trials going on. There may be hearings. There may be disputes as to whether or not someone was properly served. So the cases that are in front of us could be at various stages in terms of litigation, and particularly if the individuals are trying to work something out with the bank or they're trying to enter into a short sale, then that process will take a little bit longer. But one of the other reasons we're able to manage the numbers we are is because we have some very good staff. We're fortunate to have some very good law clerks working for us, and we also have some very good secretaries that assist us in our efforts. And we actually have law students that help us as well from the various local law schools to help us, with various research and things of nature that we need. It's a daily process where everybody gets in early and leaves late, but
Sure.
we do it.
I'm sorry.
I was going to say, so it's a colossal effort, it seems. I mean, there are so many other people involved than you would normally think. When you just kind of look, you see the judge, you see the clerk, sure, the plaintiff's attorney, the defendant, but it just seems, wow, that there are just so many other people trying to help to put the process together and to keep things running. And I guess in a call that big, you'd have to have those people.
Yeah. Right. And one of the other things I want to mention, too, is that Judge Evans started the mediation program, circuit court mediation program, and we're referring individuals to the mediation program, and the program is working. We're seeing some results. Individuals are sitting down with the bank and trying to negotiate process, see if they can maybe work into a modification. So that's one of the other reasons why maybe cases might be taking a little bit longer, because we give them a status date to determine what's going on with the with the mediation program if things have worked out.
Okay. I'd like to talk a little bit, Judge, about the process, the time frame. A lot of folks who receive a foreclosure summons are very worried. Are they going to be put out the next month? So I wanted, if we can, just to run through the process for the benefit of our listeners and viewers. I usually tell them that after somewhere between 3 and 5 months of not making a mortgage payment on time, their mortgage company is going to refer that to their attorneys to start some sort of proceeding.
Right.
And then, is that accurate?
Right. Well, and I think the important thing is, number one, when they receive the summons and the complaint, the worst thing they can do is put it in the drawer and forget about it. All right. Right. Number two, I think it's important to realize that the summons itself actually has some very important information for individuals, and that happens a lot when we see people come into court. They've never had any experience coming to court. They don't know what we're talking about sometimes, and we try to explain it to them. So I think it's important that they realize that, number one, when you look at the summons, on the back of the summons, it has some of the rights and options that you could avail of yourself if you're in a foreclosure. For example, it'll mention about reinstatement, how you might be able to reinstate the loan. Redemption, that you could, you have the right to redeem the property. So it's important to read the back of the summons. Also, to give you information about lawyer, that why you might need the assistance of a lawyer, or ask a lawyer for assistance. So I think it's important, number one, to read that summons, and then when it has the date of when you should come to court, you should come to court. You should follow the process along, so this way you know what's happening with your property, particularly in a situation where you are trying to do something to save your property. You are trying to work on a modification. You are trying to work on maybe reinstating the loan, or maybe you're working on a short sale, whatever it may be. I think it's important for you to come to court, so this way at every aspect of the foreclosure process, you know what's occurring, and you know what rights you have and what options you may have.
Okay, well, let's say they do the right thing and they follow that summons. They go down to the 8th floor at the Daily Center and they pay the appearance fee, right?
Right.
And they serve that upon the mortgage company's attorney. What happens next then in the process, now that they've actually jumped in the ring, so to speak, and ready to engage.
And I'm glad you mentioned about filing an appearance, because one of the important things about filing an appearance is that then everybody knows, everybody in the world knows, all right, that you have an interest in this property. They know, if they want to send notice, if there's other parties involved, because sometimes that happens in a foreclosure, where you have other lien holders who want to assert their right on the property. Let's say, for example, you own a home and you were having some work done on it, and then the house goes into foreclosure. Well, the people that were working on the house want to assert their lien because they want to get paid as well. So they're going to be secondary lien holders. So if they have lawyers, their lawyers are going to know, okay, we have to send notice to this individual. So appearance is very important. Also, to file an answer is very important. And if you don't have a lawyer, or you can't afford a lawyer, which sometimes is the case with someone that's in a residential foreclosure, there is the 13th floor. We have a help desk on the 13th floor. And there's always someone there between 9 and 3:30 that'll sit down with the defendants and talk to them about their case and find out what the issues are. And if they need an assistance in terms of filing an appearance and an answer, they'll assist them. However, the one thing about the help desk is that they will only help you the one time. So it's not like a service where you could continually go back and get assistance. The other thing, and the other reason why I think it's important to come to court, is because at court, all of the judges, we have a list of the legal service corporations that are in Cook County. And these are agencies that you can contact, and some of them, maybe you could get some suggestions, some advice over the phone. Some of them will ask you to come down. Some of them may end up, taking, your case depending on what the situation is. But I think it's important to realize that there is help out there. There is agencies. There are agencies that could assist you in the foreclosure process. So, once you file your appearance, once you file your answer, then everybody knows, okay, that we have to send notice, and then that's actually the next thing that will happen is most likely the bank, through their attorneys, will file a notice of motion for a judgment of foreclosure because they've already filed their complaint. Again, it's important to come to court because at that point in time, let's say there's no dispute, there's no objection to the motion on judgment of foreclosure being entered. You still have, if it's a residential foreclosure, you still have a right to redeem. And the judgment of foreclosure will give you, depending on the type of service was affected in the case, usually it's 7 months in a residential. You have 7 months from the date that the judgment's entered to redeem the property. Now, if you didn't come to court, you wouldn't know that unless they send you a copy of the judgment, which they will, but by the time you receive the judgment, again, if you didn't come in the first time, that means you're doing the same thing. You're putting the documents in the drawer, what you shouldn't be doing. And then also, you could advise the court of what's happening. But prior to that, motion for judgment foreclosure, I jumped a little bit ahead. We have what's known as the case management. And that's where we have the parties come in, and we have them explain to us what is happening. Has everyone been served? Was there any answers filed? Were any appearances filed? And that time we'll find out what was happening. The defendants, most of them, have been coming into court and they'll explain to us, I'm working on a modification, or I can't work on a modification, or I'm working on a short sale. Then this way we know. Or, I want to avail myself of the services of the mediation program. Then we'll tell them, they could go and speak to the counselors. So at the case management, we get a sense of what's happening with the case, where the case may be going, and then also we'll, again, direct the defendants to take a list of the Legal Services Corporation, and then also we have a list of the various options that are available in foreclosure also in our courtrooms, and advise them to take that as well.
Actually, I've got a few questions.
Yes.
First, mediation, is that something that is mandatory if a homeowner, which would be the defendant, wants to do mediation and the bank doesn't want to? Is that something that has to be mutually agreed upon by both of them?
Well, what will happen is when they come in front of us, the trial judges, we will refer them to the mediation. Then we'll speak to the counselors. The counselors will, after their interview, will determine whether or not the defendant, the mortgagor, may be eligible for mediation. They might be able to determine from the interview that the person's not eligible for mediation.
Which means there's no way that he would be able to come to any agreement to be able to pay
Or their means, right. They may not have the means at all to be able to try to, enter into some type of agreement with the bank. Then what happens at that process is that if they determine that the person is eligible or the parties are eligible for the mediation, then what they'll do is they'll contact the bank, and they'll try to get the parties together and sit down and try to see if they can, work something out between the parties. And part of it, what has to happen is not so much, okay, you can A and B sit down and then let's say, okay, let's work on a deal. But I think part of it, what's good about the program is that they look at, from the mortgagor defendant's perspective, okay, what is it that you have in terms of assets, what do you have in terms of liabilities, and then kind of determine, okay, what is it that you're able to work with, and what can you do without, and how can you make the payment if they do modify the payment. So it's not only about getting the parties to sit down at the table, but it's also trying to effectively see, okay, how can we work at a modification taking place? Sure. And I think that's the important part of it.
Actually, a few more questions, because we've thrown out so many terms, and it's important for everybody at home to kind of understand what's going on. When you get the summons, we talked about the appearance, there is a fee that they have to pay unless it gets waived by the court. They could file a pauper's petition.
Correct.
And ask the court to waive the fee that it would normally cost for them to file their petition.
Right.
But absent that, they would have to file they would have to pay a fee for that. Right. And we've talked about reinstatement and redemption. Reinstatement would be after the case gets filed, they would have 90 days to be able to catch up?
Well, they have until the judgment's entered. But however, the statute does, is a little vague, and I don't want to get too technical on it. Sure. But depending on if you sit down with the bank, we've seen some occasions where they'll actually continue working with the mortgagor on the reinstatement till the point when the redemption period expires.
Which is well beyond that point, which would normally be required.
So let's say, for example, you have a redemption period of 7 months. It's possible that they may still continue working with you on the reinstatement. However, you have to make sure that you get that understanding from them up front, and it's clear. You don't want to assume, and that's the one thing you shouldn't do in a foreclosure, is just assume. One of the things that we've seen that is very effective from the mortgagor standpoint is being persistent. They have to continually be persistent with the banks. The banks will respond. I mean, you have to understand from the other side, they have thousands and thousands of people, unfortunately, that are trying to reach them, that are trying to discuss with them, modifications. So, unfortunately, you may be only one of 1,000 that are trying to get a hold of the person who works in the modification department of the bank.
Okay. And that's one of the things I know that, Dave, that you've heard and that I've heard constantly, which is people working on those modifications and other things, and they haven't gotten back to me. They told them to get back to me, and and that's exactly. I'm glad you mentioned that persistence, because that's exactly what we say. A lot of times they don't want to give it. They don't want to do anything in writing. They don't want to indicate in writing, oh, well, we'll be able to do this, and I've heard that time and again.
Well, my practice is primarily bankruptcy, and I see a lot of folks who have been trying to get the loan modified, and a lot of them can't do it. Most of them can't do it, and they wind up either filing a Chapter 7 fresh start to eliminate the debt on the house, or they try and reorganize under 13. What I'm learning is that if they actually appear in the foreclosure case and start talking there, they have a much better chance of getting some kind of redress vis-a-vis the mortgage company than if they didn't get involved in the foreclosure case. So it's almost like the squeaky wheel is getting the grease here, where the people who are not in foreclosure but just trying to work it out, they're getting a lot of doors slammed, but the ones who actually come in foreclosure court and make an appearance, they're getting some redress, which is that what you're seeing?
Well, you're seeing it from that standpoint, and from our standpoint, what we're seeing is those individuals that have been able to effect a modification with the bank. What they relate to us is their persistence. Their persistence in communicating with the bank, their persistence in communicating with the bank either through phone conversations or in writing. But persistence seems to be the key here in terms of trying to get a modification. And the one thing that I do want to mention about modifications then, and the other thing that we do see also on the other hand, is once a modification is in place, It's very important to make sure that they comply with all the terms of the modification. Because if they miss one payment, the banks will come in and they'll want to reinstate the foreclosure. So, if it's due on the 1st, make sure you get it in there before the 1st. You don't want to
float your check.
You don't want to miss that payment, because then they'll deem it as a default and come in and to reinstate. Yeah. So I think that's important, and also to make sure you comply with all the terms of the modification if you are in a modification.
Do those have to be approved by the court?
The modifications?
Yes.
No.
So you don't look at the conscionability of the agreement and whether the interest rate is right? It's something
that's totally between the parties. And the only thing that we will do is we'll enter a dismissal. And in most cases, what it'll be is a dismissal with leave to reinstate. So if something does happen where the modification does take effect, then they'll come back in, because they've gotten leave of court to reinstate the foreclosure. So again, in terms of the modification, I would think it would be important to speak to someone who knows what they're doing in terms of foreclosures, an attorney or someone that's knowledgeable, and make sure that they understand all the terms. Because sometimes that's what we see, is they didn't totally understand all the terms in a modification. They didn't realize that maybe the payment was modified, but if they only make 2 out of the 3 payments, or the 3rd payment's late, that there's going to be consequences to be paid. So understand the terms of the modification.
I just want to hit a couple things, because I think it's very important. When you talk about leave to reinstate, that means that if you don't comply with it, they can come in without having to refile and having to actually serve you personally. They would just have to file a notice of motion and serve it to through the mail.
Right. Yeah. So they'll serve you with a notice of motion, indicating they're coming into court with a motion to reinstate. And again, you can come into court, and the court will explain that what's happening is that the foreclosure is being reinstated. But again, if you receive something like that in the mail, or you receive notice of it, make sure you come to court.
Okay. Is jury availability, is that possible?
No, because it's a chancery division. There are no juries.
Okay, that's important.
Well, very good. I wanted to hit one thing, and I know
we just have a minute left.
Yeah, we just have a minute left. We're really short. Maybe we'll pick it up on the next segment of this show. But when we talk about, you talked about reinstatement before, and you talk about redemption. It's my understanding that you've got, it's either 7 months from the date the last person, necessary party, was served, or 3 months from the date that the judgment of foreclosure was entered.
Right.
Whichever's later.
Right.
And so it's important to pay attention to those time limits.
Yes, it is important. And then also sometimes they will come in to ask that it be shortened because maybe the property's vacant or it was investment property, things of that nature.
Yeah. Well, this gives people a lot of time to get their affairs in order, whether it be to a traditional sale, short sale, refinance. Plenty of time. I think it's a very liberal law, probably one of the most liberal laws we have in Illinois, where someone can stay in their home and try and work out their arrangement for that period of time before they're evicted. Would you agree with that, Judge?
I think it does provide the parties an opportunity to try to, resolve their differences, particularly for the mortgagor to be able to try to, satisfy the debt. So I think that it's an opportunity for both sides to obtain what is that they're looking for.
Okay. Thank you, Judge. Appreciate you being with us today. Judge Jesse Reyes, on behalf of Jesse Barrientos, my name is David Siegel. Thanks for watching Legal Action. We'll see you next time. Take care.